We can start off with the one that came out before that, which obviously isn't as big in the news, but it's also very consequential as it relates to US law going forward. And
Right.
that's the reversal of the Chevron decision. Now, for those who don't know, Chevron was a landmark case. I remember when I was in law school, they taught it as rock solid law. You have to know what Chevron is, what that doctrine is, what it entails. And it was a deference to executive branch agencies when it came to interpreting statutes and setting policy. And so the idea is if there's no clear statutory language on point, if Congress didn't act in a very specific way in a certain area, the courts would defer to the executive branch agencies' interpretations and rules because they weren't going to substitute their own judgment for the experts that are in the executive branch agency. For example, the EPA, that was the big one. If the EPA, for example, makes regulations, as long as they're not stepping on an act of Congress, right, actual law that exists, they pretty much have broad deference because the court is going to say, look, you guys have scientists and experts, people that work for you who have really studied this much deeper than we can. We're judges. It isn't our job to be experts in the environment in these different areas, right? And so that was how this all worked, unless there's a direct conflicting statute. Unless Congress said you can't do X, Y, and Z, the courts were going to say you guys in the executive branch agencies have judgment and we're going to defer to your judgment. We're not going to override that. That was overturned this past week with the Supreme Court decision that came out, where now they're basically saying it's a jump ball. What they're saying is the courts have to interpret the statutes and determine if what the executive branch is doing is in violation. So there's no more deference that used to exist. It's not like the default position is going to be we're going to side with the executive. No, that default is now gone, and it's a de novo review. Essentially, it's up to the courts to make these decisions, even when the judges aren't prepared the same way. I mean, they're not the experts, and so they're
Right.
going to have to use their judgment on science and all these different things that they're really not prepared to speak on, and potentially go against, right, knock down what the experts in these fields are doing and saying. And
Right.
it's really a blow to not just science, right, but to the presidential power and the executive branch's power. EPA, again, being a major example of this, environmental protection. The ironic thing is that Neil Gorsuch, who's a Supreme Court justice who spearheaded this reversal, his mother was the administrator of the EPA in the 80s when the Chevron case was decided. And so under his mom's authority, the executive branch had a lot more power. These agencies had more autonomy. Now the son is dialing all that back.
Now, some of the talk on the internet about this is that with this ruling, that it kind of makes agencies like the EPA a bit toothless because was at least some of the talk is saying that these rules and regulations, companies could just choose to decide not to follow them uh, because there's no enforcement power now because of this. Is that
Well, I don't know if it's that drastic, but yes, it does weaken these agencies because what can happen is companies can choose to break the rule and essentially challenge it in court. And the court is not tasked with deferring to the EPA or these agencies anymore. And so the court is going to make its own independent judgment. Now, you may get a court that sides with the agency and thinks that the regulations are correct, are fair, right? But it isn't like it used to be where the court wouldn't even question it. That was what the doctrine always was. It wasn't up to the court to even question the policy unless you could point to a law that specifically said that you can't do that, right? That specifically contradicted that. Now it gives the courts a lot more reign to strike down these policies, to just insert their own judgment into the matter. And yeah, I think the consequence of that is you're going to see a lot less cooperation with these agencies because they're going to say, listen, we're just going to challenge it in court, or what are you going to do? What are you going to do about it? We're going to fight this, and we'll see what happens. Of course, the decision just came out, and so we don't know how other courts now are going to act. One thing I'll mention is it doesn't, this decision that just came out says that it doesn't affect the previous decisions that were made on it. So it doesn't undo all the prior cases that cited the Chevron Doctrine. But going forward, there will be no such Chevron Doctrine. And so there is going to be a lot more room for these rules to not be followed and to be struck down and for the agencies to lose their power.
And it's important to note that these courts were stacked with a lot of Trump conservative judges during his tenure. So
Yeah.
that could play into the decisions that will come out when these challenges arrive.
Right, right. Certainly if it goes up to the US Supreme Court, right? And that's an issue, I think, that is present with the next case we're going to talk about. It isn't only the decision, it's the applicability of the decision, how the decision is going to be used going forward, which is concerning.
Yeah, absolutely. Absolutely. So yeah, it's a big blow.
Right.
And it's going to
So,
have a lot of effect.
yeah, yeah, absolutely. I remember being in law school, learning about it and thinking it made sense because judges, for the most part, are not scientists. They're not experts in these different fields.
No.
So who are they to say the regulation makes sense or doesn't make sense, right? Unless Congress said you can't do X, Y, and Z, why would the courts come in and essentially make regulation themselves? I mean, that's the ironic part of this also. The conservatives usually talk about activist judges, right? Or judges who make law. And they're always concerned about that, saying it's not up to the judges to make law, it's up to Congress. Okay. But in this case, you're almost saying that the judges are to make law in a sense that they are going to, even in the absence of a congressional statute, they're going to decide whether regulations are worth keeping or not based on what? They don't have the expertise in these fields. So
Right.
why would we defer to the judges? I mean, it kind of made sense to defer to the people who knew what they were talking about.
Right. Yeah. Well, you know that people who are in opposition to that, they don't want to listen to those people because it's going to block them. And from what I understand, this conservatives have been trying to overturn this Chevron
Oh,
doctrine
yeah.
for decades.
Since the 80s when it came out.
Yeah. Yeah.
All right. And that's also, I think, what makes it noteworthy, right? We talked about obviously Roe v. Wade being overturned. People have been trying to overturn that for a very long time. It
Voting
finally,
Rights Act,
say it again.
Voting Rights Act,
Right. All these things are falling.
affirmative action.
They're right. They're all falling now. And you're right. It's not like this is the first time people have tried to challenge them, but this is the first time it's been successful because that conservative majority that they were looking for finally materialized.
Yeah, yeah. And they're continuing to fall. I mean, and I think the first big one that fell would have probably been Citizens United would probably was the first big one.
Citizens United did not fall, but that was 2010.
All
That
right, come into
decision,
being. Yeah,
yeah, the Citizens United decision basically said that money is speech and
right,
corporations have the same rights as people in
right.
circumstances. They can
Yeah.
spend as much money as they want on influencing elections.
The conservatives are playing the long game, and that's what I think a lot of people are missing out. And they're planning decades ahead, right? You stack the courts, you
Right.
stack the courts with people who have lifetime appointments. You got 30, 40 years of, leverage on your side. They're not thinking about, okay, I've got this one bill. They're like, okay, we're talking about the next 100 years here. And they're winning in that regard.
Right. And that's why we mentioned this before. An election is so important, and you shouldn't be looking at it in terms of who speaks better on stage, right? It's really more about what policy do you want? Who do you want on the Supreme Court? And like you said, not over the next 4 years. It isn't like, oh, we'll try something new for 4 years. No, what
Right.
happens over the next 4 years, 8 years could easily impact American law and life over the next 100 years, 200 years. Now, think
Yeah.
about that.
Yeah. Right. So that's, That's what a lot of people seem to missing. So yeah, that's the first one that
Yeah.
that's the first thing that fell this week. The first
Right.
crazy thing that happened this week.